From one of Australia's former leading homicide detectives, this is I Catch Killers with Gary Jubelin.
My kind of primary beef, if you like,
Yeah.
with the defence is that they didn't cast the net wide enough
Yeah.
to find psychological and psychiatric experts who could have given evidence about the diaries
Yeah.
and given an entirely different interpretation to the interpretation given by the prosecution. Never, at any point in any of her diary entries anywhere, he never admitted to harming the children physically. I think that would have had a big effect on the jury, and I just don't believe, to be frank, that Peter Zara hit back hard enough on this, and I think that one of the reasons for that, as I say, is because deep down they actually believed that the diaries were damning.
I Catch Killers with Gary Jubelin.
This is part 2 of my chat with Quentin McDermott. Quentin is the author of the book called Meadow's Law, which is about the death of Kathleen Folbigg's 4 children, Caleb, Patrick, Sarah and Laura. In part 1, we spoke about Kathleen's conviction for the manslaughter of Caleb and the murders of Patrick, Sarah and Laura. In part 2, we talk about the fight that led Kathleen being released from prison and her pardon. I think you'll be shocked by what you learn about one of the most controversial criminal cases in Australian history. Welcome back.
Thanks, Gary. It's good to be here.
Have a bit of a break, refreshed our brains on this matter, and it is complex, and I think it's something that we talk about this case. It's one of the most controversial, high-profile cases we've had in the country, and I don't think that's overstating it. The stakes were very high, and hopefully lessons are learnt from what occurred, and things can be improved. We left part 1 and we got, in our own inevitable way, we explained how it got to the point where Kathleen Folbigg was charged with the murder of four children. The trial ran for 7 weeks. It resulted in her being convicted for, I think it was murder of the 3 children.
Yes.
And manslaughter of
Caleb.
The first child. Do you want to tell us the trial, your view on the trial that occurred?
Yes. So just very broad brush, if you like. My view of the trial is that the defence was deficient, to be blunt. In one sense, it's very unfair of me to be saying this because her senior counsel, Peter Zara, and indeed junior counsel have since passed away.
Right.
And so in writing this book, I've been unable, obviously, to talk to them.
To give them the right.
But a couple of interesting things about the trial and the defence, I think, are these. That, first of all, there was only one medical expert witness appearing for the defence, and there were multiple medical experts appearing for the prosecution. Now, part of this may have been down to the resources that were available for the defence. She was being defended by Peter Zara, who was the senior public defender. Yeah. It was legal aid, and so obviously their resources were not considerable. Yeah, and that, I think, presented real challenges to the defence prior to the trial in amassing the evidence they wanted to present. And then the second thing is that only very recently, when I was researching the book, did I discover that almost certainly Peter Zara, her senior counsel, believed that she was guilty. Now, this was a really remarkable revelation. Yeah. He had a kind of private conversation following a law conference seminar with a clinical psychologist, Dr. Sharmila Betts, where she said to him, Mr. Zara, clearly this was a horrible miscarriage of justice. I'm paraphrasing, and he said, "You wouldn't think that if you'd read the diaries." So that's one remarkable aspect, I think, of the trial.
Kathleen didn't give evidence at her trial, my understanding of it.
That's correct.
Again, that's it doesn't surprise. It seems to be the thought within the legal fraternity. It's very unwise to put an accused person in the witness box because it opens them up to all sorts of cross-examination. Do you think she might have been better served? And this is two outsiders looking in, do you think she might have been better served in hindsight to explain what the diaries were about? Because in isolation,
yes,
a lot of people, and you touch on the fact that even her defence might have drawn some strong inferences from the diary. Do you think it would have served her better to get in there and explain what the diary was all about?
Look, Gary, my sense of it is that in terms of her psychological state at the time, she was in no fit state, quite frankly, to give evidence and to be cross-examined by Mark Tedeschi, who, and I mean this in a flattering way, if you like, to Mr. Tedeschi, I think would have kind of torn her apart in the witness box. And indeed, she kind of recognised this herself, I think. Yeah. But she also went on later to regret the fact that she hadn't given evidence. My kind of primary beef, if you like, with the defence is that they didn't cast the net wide enough to find psychological and psychiatric experts who could have given evidence about the diaries and given an entirely different interpretation to the interpretation given by the prosecution. Now, so, for example, in one case, in relation to one diary entry, again, I'm paraphrasing, but Mr. Tedeschi essentially said, what could she possibly mean by this other than I killed the children or I killed this child? Now, never at any point in any of her diary entries anywhere did she ever admit to any agency in killing, harming, let alone killing any of the children. She never admitted in her diaries to harming the children physically. I think that would have had a big effect on the jury. I just don't believe, to be frank, that Peter Zara hit back hard enough on this, and I think that one of the reasons for that, as I say, is because deep down they actually believed that the diaries were damning. Yeah.
Okay, it makes for a complex situation, doesn't it? And we're not looking at the we're talking in a very matter-of-fact way, but the trauma associated, and when I've said about Kathleen going into the witness box, she's lost 4 children, regardless of how that's happened. There's trauma associated with that. I don't care who you are. She's been charged with murdering the 4 children. Looking at, I think the media were doing their job. The worst female serial killer in the country.
They were, yes.
Everything that goes into play there. So the stakes were very high. The trial went for 7 weeks. She was convicted. I think she was sentenced to initially 40 years.
That's right.
30 years on the bottom. They appealed the sentencing, and I think it was reduced to 30 years, 25 years on the bottom. That was where we're at. Can you take up the case from there? Because for all intents and purposes, that could have been the last that we heard of Kathleen. She would stay in jail, but that's so far from the case. What were the things that started to turn it round where people believed her innocence and people started fighting for the justice?
Can I just preface this, if I may? Sorry, there is one other aspect of the trial that I think needs to be mentioned, which is indeed the forensic evidence. So the forensic evidence in the trial, essentially, to cut it to its most basic element, was that you can smother an infant without leaving any physical trace.
Yeah.
And kind of bizarrely, in my opinion, and this all relates to Meadow's law, that if there is no physical trace of smothering, which there wasn't, certainly no definite traces of physical smothering in any of the 4 cases, that is of itself, or of any other means of killing them, that is of itself evidence that they were smothered. Now, to me, that is almost Kafkaesque. But that essentially was what happened in the trial.
So just I'll try and paraphrase that if there's no evidence of the child being smothered, that could be evidence of the fact that the child was smothered, because there is no physical evidence of the child being smothered.
Well, I suppose there are 2 parts to it. Is there any evidence that they were killed by any other means? The answer is no.
Yep.
Is there circumstantial evidence? Or is the likelihood of 4 children dying from natural causes so unlikely that they must have been murdered? Well, if there is, then they must have been smothered. And what adds to this argument, if you like, is the fact that infants can be smothered without leaving any physical trace, and therefore she smothered them. Now, Mark Tedeschi at the trial gave various kind of scenarios as to why she might have, or how she might, why she might have smothered them. One of them was that she might have smothered each of them in turn. She might have suffocated each of them in turn in order to get them to go to sleep, okay, as opposed to killing them in a rage. That was another alternative scenario, that she flew into a rage on each occasion and she smothered them. And I think, they knew about a case in the United States there of a babysitter who had used this suffocation technique allegedly in hundreds of cases where she was babysitting children, and she would suffocate them temporarily, partially, to put them to sleep. And then, most unfortunately, she had actually killed a couple of children, and she confessed to this and was charged. And so that was one scenario. But again, it's the whole basis for this was that you can smother an infant without leaving any physical evidence, and therefore that the means by which she killed them must have been smothering. Now, in the case of Laura, that was in fact highly unlikely, because once a child of Laura's age is attacked in this way, they are going to struggle, and they have teeth, and the teeth are going to leave marks almost certainly on the inside of the mouth. And in Laura's case, at her autopsy, Dr. Carla found no evidence of this. He found no evidence that she had been smothered, or that there were teeth marks inside her mouth indicating a struggle. So really, the active evidence, if you like, for smothering was non-existent. So that, in effect, reversed the burden of proof to make it incumbent on the defence to prove that they had died from natural causes.
Yeah. Okay. Once she was convicted, who were the people that still believed in Kathy? Like, you had to have people campaigning on the outside. Who were the people, or significant people, that were fighting to get this matter overturned?
Well, it was essentially her closest friends, Gary. I mean, I think I can't imagine how hard it must have been for Kathy at the trial, because, her own foster mother was kind of sitting with Craig Folbigg's family. Craig himself had turned against her. He was an absolutely key witness for the prosecution, and I would surmise that his evidence was crucial in the jury reaching the verdict they did. So her own husband, and they were still married at the time of the trial, so Craig had turned against her, and really the only person she had on her side was this Salvation Army major, Joyce Harmer, who was amazing, and Joyce's husband Hilton, who took care of her during the trial, and I think shielded her from the worst of the media. But so she was kind of bereft, and then for various reasons, certainly her two closest friends were unable to attend the trial. So she was literally on her own, apart from Joyce Harmer's support. And then after the trial, really it was Tracy Chapman and Megan Donegan and one or two other close friends who were kind of there to support her. There was an initial appeal where, as you mentioned, her sentence was cut from 40 years to 30 years with a 25-year kind of minimum period in prison, which incidentally would have meant that she would not, even if she was granted parole, she would not be granted parole for another 3 years from now until 2028. But then after that, there was a second appeal. What happened was it was discovered that during the trial, a member of the jury, well, let me go back to the beginning. During the trial, this infamous or famous line she wrote, "Obviously I am my father's daughter," was ruled inadmissible. But when Craig was giving evidence, whether intentionally or unintentionally, he dropped into his evidence the fact that he had read this line in her diary. It was a kind of egregious, flouting of the ruling of inadmissibility. And
the weight with that wording of what she said, "I am my father's daughter," or "it looks like I'm my father's daughter," forget the exact words, given the fact that her father had murdered her mother, and the inference being fairly strong and fairly probative against her in that regards.
Exactly. Well, it was deemed by Peter Zara quite rightly put forward the argument that it was enormously prejudicial for the jury to be told about this line that she had written, because they would automatically assume that what she was, as you say, what she was referring to was the fact that her father had murdered her mother. But as I say, it was ruled inadmissible, and then Craig Folbigg mentioned it in his evidence, and then they came down with the guilty verdict. And then after the trial, after she had been convicted, of course, the media went wild. They were finally allowed to report this line that she'd written in her diary, and the media, I think, universally interpreted the line she had written as being a kind of an admission that she had killed her children. She, of course, later gave a very different explanation for why she'd written it. She said, look, all I was saying there essentially was, my dad was a loser, and, my life has kind of gone to shit, basically, and, I've turned out to be a loser as well. That was her explanation for it. But for the second appeal, this was one of the grounds of appeal, that there'd been a clear breach of the rules by a member of the jury, and therefore, essentially, that there should be a retrial. And I think what I found interesting was that at the appeal, the Crown argued that when this information went back into the jury room, it would have elicited sympathy from the other members of the jury. Now, I personally find that absurd.
Look, we're talking hypothetically if that's what happened, but I don't think, I'm not picturing the jury room going sympathy. I'm thinking, right, we've cracked the case.
Exactly. Yeah. Exactly so. And so I find that, to be frank, an extraordinary decision of the appeal court, the Court of Criminal Appeal.
How did it get to the point where there were inquiries?
Okay, so I'll kind of flash forward, if you like. In 2011, Emma Cunliffe, who is Australian, a legal academic, she's now a professor, but who had moved to Canada, she started looking at this case. She was actually, I think, looking at the case of Lindy Chamberlain at the time. But as she describes it, she realized when she started researching Lindy's case and Kathleen's case that there were all these other mothers in the UK in particular who had been convicted largely on the basis of Meadow's law, or to a great extent on the basis of Meadow's law, but who had since been acquitted. And the only mother who had not been acquitted or on appeal was Kathy. Okay, so she started looking at the case, and she's quite clear in conceding that she started off with the view that Kathleen Folbigg was guilty. And she also is very clear in saying that when she started reading her diaries, she was very troubled by them.
Yeah, I found that very interesting, because that was her initial reading the diaries. She saw something sinister there, but then she changed the view on it. Yes,
that's right, and I think a lot of people have probably, including myself, have gone through that kind of process of reading some of the entries in the diaries. The most famous one of which is, apart from I'm My Father's Daughter, is probably the one where she says that Sarah, left
with a bit of help.
And you think, oh my God, what is she saying here? Now, her explanation for that has always been, and consistently actually since the very earliest days, has always been that what she meant by that was that she left with some kind of divine or supernatural help. It's a kind of semi-religious kind of idea that she was taken from me by God, or however you want to express it, or a higher power. But Emma, not uniquely, was very troubled by that, and I think may well have thought that she was guilty. But the more she looked into the case, and in particular the more she deconstructed the trial itself, the more convinced she became that Kathleen was innocent. And so she wrote this book, which was a kind of seminal book, really, about the case, which was published in 2011, Murder, Medicine and Motherhood. That was read by, amongst other people, a close friend of Kathy's, Helen Cummings, in Newcastle. And she approached Isabel Reid, who is a barrister in Newcastle. Isabel Reid then got other lawyers involved, and so round about that time, 2011, 2012, lawyers in Newcastle, and indeed the University of Newcastle's legal centre got involved, did a lot more research, the legal centre, into the case and the transcripts and everything else. And eventually, in 2015, a petition was put together, and it was sent to the then Attorney General of New South Wales, Gabrielle Upton, calling for a judicial inquiry into her case. Now, one of the key aspects of that petition, in my opinion, the most crucial aspect of it, the most crucial element of it, was an enormous report which was written by the esteemed forensic pathologist Professor Stephen Cordner. And he'd spent over a year reviewing the forensic evidence in the case. And his very clear conclusion was that there were natural causes of death for all 4 children, and there was no evidence whatsoever that she had been smothered. And not only that, there was actually robust evidence that Laura had not been smothered.
Because she didn't have any injuries supported with that.
Exactly. So this was presented in, I think it was May or June 2015, to the then Governor of New South Wales, and then passed on to the Attorney General. Gabrielle Upton, and then Mark Speakman, her successor as Attorney General, came on board. And then following on from that, in 2017, I became involved in... Well, I should, in fairness, I should add that after Emma Cunliffe's book was published, 60 Minutes did a story about her case, and they interviewed Emma Cunliffe. And bravo to 60 Minutes, who actually followed the case right the way through, pretty much to the very end, and consistently argued that there were reasons to doubt her guilt. So they did that. But then in 2018, I was working at Australian Story, and I produced a story, an episode, a longer than usual episode for Australian Story about Kathy's case. Yeah. And one of the things, I guess there were 2 important elements of that story. One of them was that I decided, after reading as much of the evidence as I could, that there was a clear conflict between what Professor Cordner had said, which was that there was no forensic evidence to suggest that they'd been murdered, and what Dr. Alan Carler had said, which was supporting the view that all 4 children had indeed been smothered. And I was able, an entirely independent forensic pathologist called Dr. Matthew Ord, who incidentally was based in Canada along with Emma Cunliffe, was suggested to us as someone to approach. I approached him and I said, look, would you be prepared to do 2 things to kind of review Stephen Cordner's report? And Dr. Ord had nothing whatsoever to do with the case prior to that, which I thought was a good thing. And secondly, if we can arrange for the slides of Laura's heart tissue to be delivered to you, will you examine them and kind of tell us what you think? And I didn't know what his conclusions would be. He might have said, he agreed to do this, but he might have said, look, I don't agree with Professor Cordner's report, and I think that the myocarditis that Laura was suffering from, that I agree with Dr. Carler that it was only patchy and mild. He might have said that. In the event, he said that broadly he agreed with everything Professor Cordner had written in his report, and he thought that there was a very clear case of myocarditis which could have caused Laura's death. The phrase he used at one point, he qualified it. He said that didn't prevent the possibility that she might have killed Laura, but he said that in his opinion this was, to quote, an eminently fatal case of myocarditis. Right. Now, I was kind of at one level stunned by this, because I thought, well, my God, if this entirely independent forensic pathologist is saying this is an eminently fatal case of myocarditis, why was she ever convicted? And after he said this, I came back and I I interviewed Nicholas Cowdery, who was, of course, the Director of Public Prosecutions when Kathleen was put on trial. And interestingly, he said a couple of things in relation to the pigs might fly. Quote. He said, "Well, look, that's not how I would have presented it." But in relation to this, he said, "Well, even if this went to the Court of Criminal Appeal and she was found not guilty, she was acquitted of her conviction of murdering Laura, that wouldn't necessarily mean that the other convictions wouldn't stand.
Yeah,
and I found that absurd. I'm sorry as well, because it was the coincidence evidence that
was
helped
the strength of the
convict her.
case. Yeah.
So so we then put this story to air in August 2018, and I think it's interesting. I'm sure you found this, Gary, in life as well as in investigations and so on. Timing is everything.
100.
So, I pay tribute, as I say, to 60 Minutes, and there were one or two other great journalists who had written articles and so on prior to 2018 saying, there questions need to be raised about this case. But I think the timing of this was critical of our Australian story. And one of the other things that Nicholas Cowdery said on camera was he said that he believed that the delay in deciding on the petition, which by then was more than 3 years, was an inordinate delay.
Does seem exceptional.
And 9 days later, Mark Speakman got up and said, "Okay, we're going to have an inquiry into her convictions." And it's interesting that the key point that he said the inquiry would consider was this whole question of whether there had ever been other cases of 3 or more deaths of infants in a family, from natural causes. And all of the medical experts who gave evidence at her trial, at Kathy's trial, had said they'd never heard of a case like that. Yeah. And then, Mark Tedeschi himself had kind of emphasized that by saying pigs might fly. And so the jury... it became very, very apparent, and Emma Cunliffe pointed this out in her book, that there were, of course, other cases where 3 or more children had died from natural causes, and so this was one of the points that we raised on Australian Story, and it was one of the probably the key point that Mark Speakman raised in announcing this first inquiry.
It's When you break it down, it's still complicated. But at the time, I can just imagine all these things coming into play. The inquiry was ordered, so I think there was 2 inquiries, wasn't there?
There were 2 inquiries, and can I just mention one other really critical thing about the petition? Apart from Professor Cordner's extensive and exhaustive report, there was also a report by a British mathematician, Professor Ray Hill, who had given evidence, as it happens, or presented evidence to Sally Clark's successful appeal. And for me, this was a kind of epiphany. And essentially what he said was that, while the chances of 4 children in a family dying from natural causes it's a rare event. Yeah. The chances of all 4 children being killed is much rarer. And he actually produced some statistics. He said that his own rough estimates, which he had published in a paper, was that single cot deaths outweigh single infant murders by 17 to 1.
Okay. Yeah.
Double cot deaths outweigh double infant murders by about 9 to 1. Yeah. And triple cot deaths outweigh triple murders by about 2 to 1. Yeah. So, the whole basis really for Meadow's law and for the prejudice, if you like, that if 3 or more children die in a family, it has to be homicide, was based on a faulty statistical assumption.
The statistical analysis could be flipped to work against it. That's what you basically explained there. So. It's with all the experts that you get in, and you mentioned earlier, and I just want to read it out when we talk about confirmation bias from your book, an extract from your book, because Dr. Cunliffe has made this comment on the basis of Dr. Carla's evidence, and I recall when you said information was passed on to another expert when you were doing the research, and you were very careful not to provide too much information. I'll just read this out, and then I'll open up some discussion there. So Dr. Cunliffe made this assessment. Cognitive science, she explained, shows that when someone believes that there is a likely explanation of a phenomenon that they are observing, they are more likely to notice evidence that supports that conclusion and less likely to notice evidence that contests their conclusion. That is what leads to the definition of confirmation bias. I've always had, and I'm talking in a general sense here, issues and concerns when it might be the prosecutor. We go to an expert, an independent expert, because they're a medical person or a scientist or whatever, and they can be totally objective. But we say, we've got all this information, can you test this and provide this information and give us a report back? I think there's contamination time and time again when experts are providing their expert opinion based on what information are provided to them. The first inquiry, all this evidence that we've explained and contained in your book, the overwhelming evidence that you would think would carry some favour at the inquiry, which was headed up by Justice Blanche, I believe.
That's right.
And but that was rejected.
Yes. So, look, it was in some ways, a lot of the evidence presented at the inquiry was extremely complex.
Yeah.
The neurological evidence and other evidence, I suppose to cut to the chase, the first inquiry, there were several kind of important hearings that took place. One of them was indeed with 4, I think it was, forensic pathologists, including Dr. Carla and including Professor Cordner, where, broadly speaking, the forensic pathologists all agreed that, yes, there were plausible or possible natural causes of death for all 4 children. But Gail Furness, who was the senior counsel assisting the inquiry, asked them, is it possible that these children, despite the fact that they may have died from natural causes, is it possible that these children were smothered? And of course, each of them had to say, "Well, yes, it's conceivable," kind of thing. So that was one part of the evidence. And then a second part of the evidence was this extraordinary kind of revelation, actually following on from the Australian Story episode that I produced, that there was fresh genetic evidence demonstrating that Kathleen Folbigg and her 2 daughters, Sarah and Laura, were all suffering from a cardiac genetic mutation, which, in the view of the leading geneticists who uncovered this, was potentially fatal. That it was likely pathogenic. Now, there was an enormous argument, essentially, at the inquiry about this. There were kind of clinicians on the other side who were deeply skeptical about this. But the geneticist, the immunogeneticist, Professor Carola Vinuesa, who made this discovery, was equally clear that, in her opinion, this raised reasonable doubt about her convictions, and that maybe this genetic mutation had indeed triggered the deaths of Sarah and Laura. And the basis on the theory that she was putting forward, essentially, if I can kind of put it crudely, is that both Sarah, who had an infection before she died, and Laura, who had myocarditis, that this triggered this genetic mutation, which essentially causes arrhythmias in the heart and can be fatal. It can cause fatal arrhythmias, and that is how they died. But at that stage, at the first inquiry, it was still at a very theoretical point.
Because this is science. The genetic science is something that's evolved after the conviction of Kathleen.
Totally, that's right.
So this is new science.
This is new science. Yeah. It couldn't have been carried out in, genetic science was in its infancy, essentially, in 2003. Those tests could not have been carried out in 2003. It was only, 15 years later that they could be carried out.
Yeah.
And it was a remarkable scientific feat, actually, to enable those tests to be carried out on the heel prick cards and other.
Just explain that the heel prick cards are what when children are born, a blood sample is taken from the child, and that's what they relied upon.
Exactly.
For the
Certainly.
DNA.
Yeah, that's right. So it was a remarkable feat. They established that Kathy, as I say, had this genetic mutation, carried it, passed it on to her two girls. Craig Folbigg, most unfortunately, refused to give a DNA sample, which could have aided the scientists considerably, and he refused to do this. But be that as it may, there was this fresh genetic evidence which pointed to the possibility, at least the possibility, that two of the children had died from this genetic cause. And then the next element in the first inquiry, which was highly significant, was Kathy agreeing to give evidence herself about the diary entries she had written and what they meant.
And that's what we talked about that before. She didn't give evidence at the trial about that. So this is at the inquiry. She said, yes, I'll do that.
That's right. And she had actually talked about some of the diary entries on Australian Story.
Yeah.
So, because we had recorded conversations that she had from prison with Tracy Chapman, her best friend, and we'd recorded them with Kathy's agreement and with Tracy's agreement.
I'm glad you clarified that in light of what ended my career. Thank you very much. Go on. We know all about that.
Well, yeah. I mean, can I just say, I think, I think it was actually quite, in some ways, courageous of Kathy to do this, because, I think she could have been severely punished for doing so. Yeah. Talking to the media from behind prison walls is probably not universally approved. But be that as it may, that was a kind of friendly discussion that she had with Tracy, a series of conversations actually, because as you know, obviously each conversation is cut off after 6 minutes. So a series of at least 15 conversations during which she explained what she meant by some of these diary entries. So that was a kind of friendly exchange, a friendly explanation. And then fast forward to 2019 when she agreed for the first time to give evidence in a court about her diaries. And I can only describe what happened as, brutal, actually. This was supposed to be an inquiry where I think all of her friends and supporters and probably her legal team assumed that she would be asked in an entirely neutral way to explain what she meant by many of her diary entries. What in fact happened was that she was cross-examined in really ferocious fashion by two senior counsel, at three if you include Gail Finesse, who was less ferocious, over 2.5 days. And she was challenged 69 or 70 times during this cross-examination to admit that she had killed one or more of the children. And every single time she denied it. So, one absolutely fundamental point here is that Kathleen Folbigg, has never once intimated, let alone admitted, that she has harmed any of her children. And, again, you will know better than I do, Gary. In many cases where people profess their innocence of murder charges and then they're convicted and they go to prison, they finally fess up and they say,
I have a lot in there that still maintain they
no,
didn't do
well,
it, but
that's true too. But anyway, so that was the third main element.
Just on that point, with the rigorous cross-examination, there can be a counter-argument there that if someone is tested strenuously and they stand up to that test, that might be more revealing than if the questions weren't asked. Is that reasonable to suggest that?
Yes, no, I think that's fair.
Yeah.
And I'm not suggesting for a moment they should have been, it should have been a kind of cuddly, warm exchange. Of course she should have been challenged about some of the more contentious entries she wrote in her diaries, and some of the entries which to many remain to this day troubling.
Yeah.
Of course she should have been challenged about that, but my point is that it was relentless. Now, interestingly, one of the psychologists who gave evidence at the second inquiry used the word brutal. Yeah. About that was his assessment of the cross-examination which had taken place, and in my opinion, it acted almost as a substitute for what didn't happen during the trial.
Yeah, I saw that in the book that you. Okay, well now we've got an opportunity.
Now we've got her on the stand.
Yeah.
We're going to nail her.
There seems to be, and I was going to talk about this later, but there seems to be that real division between the legal fraternity and the medical and science fraternity at loggerheads about this whole case. It seemed to be people in different camps. Am I reading it right? That's
Yes, I think that is right, and I've written about that prior to the book, and
Yeah.
that's certainly a major theme of the book, is that it ended up being science versus the law.
Yeah.
Now, that is, of course, in one sense, a kind of crude summary, because there were some scientists who kind of didn't believe the fresh genetic evidence
Yeah.
should carry as much weight as in the end it did.
Mm.
But what happened what happened at the end of the first inquiry? A couple of interesting things. First of all, there was an expert overseas, a world expert in cardiology and genetics called Professor Peter Schwartz, who wrote to the inquiry once he heard about the case and the evidence, the genetic evidence. He wrote to the inquiry and essentially said, I can't make a judgment about this, but I think this calls her convictions into question, and essentially called for further hearings to investigate the genetic science further. That didn't happen. So the Commissioner, Reginald Blanche, handed down his report and dealt with the fresh genetic evidence in an appendix. It wasn't even part of the main report,
Right.
and which I think a lot of people found quite troubling. And given that this was supposed to be an inquiry, not a trial, and he said his judgment was that the evidence that he had heard reinforced Kathleen's guilt.
Right.
I mean, it was to many that was an astonishing.
I know. There was a lot of people that took that quite confronting. That was the findings from that inquiry.
Well, I think a lot of people who were kind of on her side, if you like,
Yeah.
found that quite shattering. Actually, they just could not believe that he'd said this. He also said in his report, incidentally, that it was plausible that each of the children might have died from natural causes, but he said that. Given that the lies, as he described it, this was his personal interpretation of the evidence she had given in person, lies and obfuscation, that the evidence he had heard reinforced her guilt. And he said that the only means possible by which they might have been killed was by smothering, and that there was no other person who might have done that. Now, again, I found personally that's shocking, because there was another person who could have carried out
Craig,
who could have killed the children, Craig, and the transcript of the secretly recorded conversation in which he laid out in detail how he could have killed the children and his motive for doing so was suppressed by the first inquiry. It wasn't allowed into evidence.
Yeah. It's confusing, isn't it? And I say that, but I'm saying it genuinely. It's confusing, like the way courts, inquiries, and the evidence that gets presented. So you've had an inquiry. There's been the petition. Was there at any point that people were going to give up? You're involved in it by this stage. You've been covering it. You've been reporting on it. All the people coming in, I know there were people from Newcastle. Newcastle University would contact me about it, and a friend, Xanthia Mallet, was a criminologist up there, and we're friends, and she would quite often talk to me about this case, and I'd be going, no, like I would just push back for the sake of pushing back, but she was adamant that no, there's been a miscarriage of justice, and even to the point when in discussion she'd say, well, okay, let's say, and I'm talking hypothetically here, make sure we clarify that she was guilty. There still wasn't sufficient evidence for that person to be convicted at trial, and that sort of sat with me. I understood where she was coming from there. We're not talking about guilt or innocence here. We're talking about there wasn't enough evidence for this person to be convicted at court. So that got me looking at it a little bit further. Then you've done my head in with reading your book. But where to from there? First inquiry, and Blanche came back stronger than anyone would have anticipated in his findings after the first inquiry, the commissioner from that inquiry. So what was the next move?
Yes, and look, he could have come back. I suppose he could have come back with a finding that, the fresh genetic evidence was kind of interesting but hadn't been fully developed or whatever. But he didn't. As you say, he came back with his own finding that the evidence he'd heard reinforced her guilt. Now, at that point, you're quite right. I think a lot of Cathy's supporters kind of fell in a heap after that. They just couldn't believe it, and one or two of them, I think, kind of gave up, essentially. Yeah. The one scientist who didn't give up was Professor Vinuesa, and to her eternal credit, I think, she helped to kind of broaden the scope of the inquiries into this genetic mutation, which ended up with a team of 27 scientists around the world putting together a paper which essentially which followed on from laboratory experiments which were carried out in several different countries to examine whether this genetic mutation was actually pathogenic or not. And again, I'm paraphrasing, but essentially they came to the conclusion that yes, it was pathogenic, and that it likely killed or triggered the deaths of Sarah and Laura. Yeah. Okay, and they wrote this up in a peer-reviewed paper for a publication called Europace, which is published in Oxford in the UK. And so, based on this, there was then a move to corral or invite, actually, other scientists and science advocates to endorse a second petition on her behalf, which they did. And among the scientists who endorsed this petition, after reading the Europace paper and considering all the evidence, were 2 Nobel laureates.
Okay.
So, which I believe is unique in the whole kind of history of cases like this around the world.
Someone putting their name at that
putting
level.
their name to that and endorsing it. So that petition was then lodged with the Governor of New South Wales and with Mark Speakman, who was still the Attorney General. At the same time, Cathy's lawyers had launched an appeal essentially asking for Reginald Blanche's findings to be quashed from the first inquiry. And that appeal, the hearing took place, and then the judgment came down very shortly after the second petition had been lodged, and the appeal finding was negative. It was they refused to quash the findings, and indeed they essentially agreed, the judges, with Reginald Blanche on all the salient points that he had made. But there was an enormous burst of publicity, which I go into in the book, how it was organised and so on, surrounding the second petition. And I think what that did was I think it helped to move the dial of public opinion about Cathy's guilt or innocence. And so by the time the second petition was lodged, I think public opinion was moving steadily more in Cathy's favour.
Just to interrupt there, it wasn't just the public opinion that was changing. Cathy's life was changing on the inside too. That when she was in prison, going in as a convicted child killer is not a good place to be. But I found it interesting at that particular point in time, even her fellow inmates started to look at her a little bit differently and treated her differently at that stage. That's
right. And obviously she was considered to be the lowest of the low when she was convicted and went into prison, and I don't think she was able to speak to another inmate probably for about a year. I think it must have been horrific for her, and she thought the whole time that she might be poisoned or whatever. Yeah. And then I don't think that Emma Cunliffe's book, and this is no disrespect to Emma, her book was brilliant, but it's an academic book. I don't think that kind of shifted the dial particularly. I think the first 60 Minutes, which I believe was in 2012, may have shifted it slightly. But then I think our Australian story in 2018 certainly had a beneficial effect. And it's interesting that when we were filming that, we were filming outside the perimeter of one of the prisons, and I spoke to a prison guard who was escorting us around, and I just asked him, what do you guys think, kind of thing. And he said, oh, no, we all think she was innocent.
Right. Okay. Interesting.
And, which is interesting because it's the old thing of, if anyone knows whether someone's guilty or innocent,
they have an instinct
it's the
for
prison
it.
staff.
They've seen enough in there.
So that was interesting. And then finally, when the second petition was lodged and it was endorsed by 2 Nobel laureates, I think that really she then began to be treated much, much better inside, and to kind of enjoy the support of other inmates, which of course must have been a gigantic kind of weight off her shoulders.
Oh, definitely.
So then Mark Speakman did not come down with his decision on the second petition for another year. And what was happening here, and this relates to science versus the law, if you like, what was happening here was that the Australian Academy of Science had become involved. And there was something called Team Folbigg, which was a kind of team of businessmen and philanthropists and others who had become very involved in behind the scenes in her case and in kind of pushing the science forward. And the Australian Academy of Science, their former president, John Shine, Professor Shine, spoke out very strongly and repeatedly, saying, the evidence is in, essentially, scientifically. The evidence is in that there is a genetic cause for the deaths of 2 of the children. Why don't you, referring to Mark Speakman, why don't you recognize that, please, and pardon and release her? Because the request in the second petition was for Kathleen to be pardoned and released. And at any point from then on, the Attorney General could have made the decision. He had the power to do that. He had the power to recommend to the Governor of New South Wales that Kathy be pardoned and released. And he didn't do so. But eventually, about 13 months later, he announced that there would be a second inquiry.
It is such a complex case, what we're talking about here, with Kathy's situation. I can see people are defending their position, or people are doing their job with the same vigour that the prosecutors, I make this observation in the book, the same vigour in which the people involved in the prosecution of Kathy demonstrated was also demonstrated by the people that were fighting for her freedom. So
that's absolutely right. Yeah. And is it right? Let me ask you this question, Gary. Is it right that Kathy was eventually pardoned and released only after, members of her legal team had worked thousands of hours pro bono, money had been raised, it kind of to help her defence by, philanthropists and senior businessmen, and scientists like Professor Vinuesa had given up hundreds and hundreds of hours of their own unpaid in order to further the science that eventually helped to release her? Is it right that those factors came into play? Because without those factors, without that help, almost certainly we would not be having this conversation today.
No, and there was so many times when she could have been left there, and that's the end of the Kathy Folbigg story. But there's a disproportionate, what you're saying there, the resources available to someone taking on the power of the state is always disproportionate. We need to have a situation that's protected as best it can be. But you're quite right, without that input. And I know the people I was speaking to, how passionate they were about, it was a wrongful conviction. And we wouldn't have got to that point if these people didn't continue on. The actual, the process in which she was granted, so last, where we were talking about, it was back with Mark Speakman.
Yes.
Second inquiry.
That's right. Mark Speakman, overall, and again, I don't question his integrity, and he's emphasised repeatedly that he had to take detailed legal advice on both petitions.
And further advice was coming in
it was, and the paperwork was voluminous and so on. But I have to say this, overall, taking into account both petitions, it took 4 years in all for him to call those 2 inquiries. Anyway, the inquiry was called, and then at the inquiry itself, there were 2 kind of fresh elements, I suppose. One was that there was the evidence given in particular by 2 Danish scientists who had conducted further research into the genetic mutation and found it to be pathogenic. And their very clear view was that the genetic mutation had triggered the deaths of Sarah and Laura. And then the next and highly significant part of the fresh evidence was the expert opinions of, as you've said earlier, of 9 or 10 psychologists, expert psychologists and psychiatrists, all of whom agreed that the entries she had written in her diaries were not incriminatory. They were not admissions of guilt in the agency of their deaths. They were not admissions of guilt to having killed her children. They were, the diaries were suffused with expressions of the personal guilt that any mother would feel, and the distress and the depression following the deaths of her children, but they were not in any way, shape or form admissions of guilt. And interestingly, right at the end of the second inquiry, the DPP essentially kind of threw in the towel and agreed that there was indeed reasonable doubt at that point now surrounding her convictions. So there was the fresh genetic evidence, there was the fresh evidence about the diaries, and in the end, Sophie Callan, who was the counsel assisting Tom Bathurst, who was the former Chief Justice in charge of it, they both agreed that there was reasonable doubt. There were some scientists who were resisting this, but I think all but one said that there was a reasonable possibility that this genetic mutation could have killed Sarah and Laura. And so in the end, the new Attorney General decided on the recommendation of Tom Bathurst to pardon and release Kathleen. And that happened in June 2023. And then 6 months later, in December, following handing down his report, her case went to the Court of Criminal Appeal, where she was formally acquitted of all 5 charges.
So breaking the pardon down, that was, as the word would imply, she's been pardoned, she was released, but the acquittal followed on from the Court of Criminal Appeal, so saying that the conviction's no longer valid.
Yes, and the acquittal was crucial, of course, because even after she was pardoned and released, Craig Folbigg was saying that he still believed that she was guilty.
Yeah.
Sadly and unfortunately, so many potential witnesses had died in the meantime, and indeed last year, following on from this, Craig Folbigg tragically died himself.
Yeah.
So a retrial was never on the cards, and it would have been frankly absurd to suggest that. But the acquittal was absolutely key, because it wasn't just a case of her being pardoned for what she had done and released. It wasn't just the criminal justice system saying, okay, you've kind of served your time, you've suffered enough, we'll release you. It was critical because under the eyes of the law now, in the eyes of the law, she is now an innocent woman. Yeah. She has been acquitted of all the charges.
Yeah, it's significant. An amazing story, complex story that really calls into question so many different aspects of our justice system. How is she now? Do you have any contact with her since she's been released?
Yes, so Gary, I've met her a couple of times. Yep. There was on the day of her acquittal, there was a special lunch put on by kind of Team Folbigg for her, and of course she was, very happy at the result, the legal result. But I don't think there's no getting away from the fact that her loss has been terrible, and the trauma that she suffered has been appalling over the years, and it's lasted for decades.
Yeah.
And so, is she okay? Yes, she's okay. I'm in touch with her kind of from time to time. She has a very close circle of friends who are there to support her every day. And so, I'm very optimistic that she'll be okay. But I mean, as I say, there's no getting away from the tragedy of this case. There's no getting away from the fact that the broader Folbigg family, as well as her, lost 4 children, and that tragedy may be kind of softened by time, but it certainly doesn't leave us all.
Yeah. No, it's a heavy story. I want to thank you for coming on I Catch Killers. I've found it fascinating. I'm not going to thank you for dragging me back into a world that I've left. I was sitting there reading your book with my homicide hat on, just going, okay, making notes. I just found it fascinating, and I just want to say everyone involved in this case, it was a difficult case all round. You look at, and I'm not just talking from the prosecution, from the defence, there were so many complexities in there and subtle little things that you had to look at that I could imagine it's broken a lot of people. Your book must have taken you a lot of time to prepare, but it certainly details the nuances of what happened with this matter. It's given me a greater understanding of what's happened with this case. So when I do offer an opinion now, I can offer it with some informed opinion, other than just taking, no, it must be guilty, she was convicted. So.
Well, you know, Gary, even now, after writing the book, the first question that almost everyone asks me is, did she do it?
Yeah.
And so my recommendation to all of those people is go out and buy the book and read it.
Go out.
But look, thank you for inviting me on, and I found it too to be a really fascinating exchange of views, so thank you.
Oh, well, thank you. Cheers.